Okay. All right. So for tonight, we are going to continue from the last time where we stopped. Okay. So in the previous lecture, we discussed about consent in a scenario pertaining to employment. Okay. If you still remember, we look at some of the cases. Okay. In the previous lecture, we started with the case of ICI. Okay, and then it's about working in quarry. Okay. And then we discuss Smith and Baker. It's about rock cutting. And then we discuss about Toddy Taper, okay, Kanaga Sabapati. And we discuss about a driving school teacher, okay, lesson, Nettleship and Western. And last but not least, the case that we discussed last two nights, Boater and Rowley Regis Corporation. Okay, so for tonight we are going to continue, but now we are focusing on different scenario. Okay, I think it's relevant to many of us here. I think many of us, especially my students lah, because you are all young people, so many of you love sports, I believe. Even though not to play sport, but maybe to watch or to view sports. Okay, so now let's have a look. What's the legal position of consent in sport? I mean, if whoever is involved in sport got injured, okay, during the games, okay, during the sports, during the participation, can I mean, can they claim? All right, can they claim?
Sabar saya tu nak habiskan cepat.
Can you mute yourself? Right. Can the defense would the defense be available, okay, against the defendant, those who cause injury to, I mean, it could be both the one who are involved in sport, okay, both the participant, but maybe one sportsman cause injury to another. So would this VNFI, voluntary non-free injury, be available, okay, so that they don't have to pay compensation, right? So that's basically the question or the issue that we have to look into. So basically, generally, yes, okay, the rule is applicable because why? Consent to an injury, it will be applicable. It applies, okay, when the injury, it depends on the type, on the nature of the injury. So it is the injury in which the type or the kind which is inherent, which is something which is attributed or which is a part of it, attributes of it, okay, and it happens under normal circumstances, okay, and of course all the rules are I mean they comply with the rules, then only the rule might be applicable or might be relevant. So who are the parties that could use this defense? Okay, I mean it is applicable. It is available to sportsmen. I mean the one who participate in the sport itself, and then officials, whoever. I mean the staff, okay, whoever working together, okay, in order to organize the sports, as well as the reporters. So reporters are very important, as well as all of us here. I mean if you are not, if you are not playing sports, okay, you are the spectators. We watch or we view the sport. So the rule actually basically it will be applicable, but it depends on the situation. That's why we have the third bullet here. However, I mean it depends on the circumstances, because sometimes despite that VNFI is applicable in sports, but then maybe there could be lacks of consent. Okay, meaning that here you can still ask for compensation, and then the defendant cannot protect or cannot run away from liability by using this particular defense. It depends very much on how it happens. Okay, so we have few cases in order to see whether the court allows this defense to prevail or not. So the first case for tonight is, the case name is Afutu Narti and Clark, 1984. All right, let's have a look at the facts here. It involved a certain student, okay, pupils here. So defendant was a qualified PE teacher. So it's between teacher and student. And the teacher, he was coaching a rugby. So now the sports involved is rugby. So rugby usually it involves physical, okay, physical touching, and then there could be injury, something which is inherent, okay, which is link, okay, which is associated, okay, it is part of the game itself. So here he was coaching, he served as a coach to a group of 15-year-olds, mean that here secondary school students lah, okay, I mean not that old but not that young as well. And then what was his task or his job here? So he was supervising and he becomes the referee. Okay, he was refereeing, and as well he joined in the game. Okay, why did he join the game? To even up the numbers, to make up the numbers lah. Okay, to balance the numbers. So he is also playing together with this form 3 students lah. All right. And then in one of the occasion, okay, that's why we have the case here. So this teacher, the coach, okay, the teacher, he tackle is one of the movement lah in the game. Okay, he tackled one of the 15-year-old players. Okay, and the student fell, and then it caused serious injury. Okay, to the spine. Remember, spine is very important because it might cause. The person can become paralyzed. Okay, because if there is any injury, serious injury to the spine, and then the case was brought to the court. Okay, to see whether the teacher should be liable or not. And the teacher was trying to argue under this Volenti and free injuria. But the court held that the teacher was negligent. Okay, there's very obvious negligence here, and he was in breach of his duty of care. Duty of to take care of the student here. And this is what the court said. Okay, the judge said that it is wrong and it is a breach of duty of care owed to schoolboy for a master. He's the master. In superior position for a master taking part in the game to have any intentional physical contact with the boys. He could join, but then he needs to be very careful, okay, not to cause any injury to the student. After all, he's older. Okay, in terms of the energy, in terms of the skill, is not even lah. Okay, all right. And the judge also said, why the teacher was held liable and the defense was not available to him, okay, because he was the defendant. So the judge also said that there was no problem, okay, with the teacher taking part in the game. It's okay. It's normal for the teacher to join in the game. But for this particular case, okay, the acts of negligence was in the intentional physical contact. The tackle shouldn't happen. That's what the court said. Okay, and intentional physical contact, okay, was accepted as a normal course of events in rugby. But then for this particular case, okay, this still did not prevent the teacher from being negligent. The way the injury happened, so it doesn't absolve the teacher from being liable, from paying compensation. Okay, so normally, yes, VNFI is available to the teacher or to the coach, but for this particular case, as if the teacher goes beyond the limit. So he was so into the game, he was so excited, as if he was treating the game as a very serious one, whereas it's just a training. Okay, so that's why the court said no, you cannot use VNFI for this particular case. So this is an example in which VNFI is not applicable. But let's compare with this one. Okay, this is actually leading case. If you read any of the textbook or any of the references, you will come across this case. So, it is also example whatever happened in sports. So the case name is Woolrich. Okay, take note of the spelling. Wool, okay, O and then LD and then Rich, Woolrich, okay, Woolrich and Sumner, not Summer, Sumner. So reported in 1963. So we go to the rule first. This is the rule that we extract from the case, or this is the ratio, okay, the rule that we derive from this particular case. So it is stated from this case, a person, okay, attending a game, a competition, okay, takes the risk of any damage. If you were in the game, so you have the risk, okay, you might be suffering from injury caused to him by any act of a participant done in the course and of and for the purposes of the game or competition. Okay, and then the court also went to explain it further. Okay, that is notwithstanding that such an act, okay, by whatever act of the participant here, may involve an error of judgment or lapse of skill. For example, you want to jump at this distance. Normally, people jump at this distance, but maybe because of error of judgment whatsoever, so it went beyond the boundary, for example, and it hurts whoever watching the game, for example. It happens, okay? So the court acknowledged this fact, okay? But the court said, unless the participants' conduct is such as to evince, okay, a reckless disregard for the spectator's safety. It depends, okay? When the error of judgment happen, we need to balance, okay? Who's more at fault? Who's more careless here? Who the recklessness here? Does it go beyond the normal limit? So this is the quotation or the judgment by Diplock, okay? Lord Diplock. All right, let's go to the facts of the case. Woolrich and Sumner. So who was the claimant in this case? So he was a photographer. Okay, so he was working at a horse show. So he's supposed to take picture of the one who rides the horse lah. Okay, during the show. All right, and then in terms of position, I mean, in order to have a good shot, okay, here, so he was situated within the ring. Okay, you can imagine there's a ring. It's like the enclosure, okay, within the ring where the horse show took place. Actually, he was supposed to be behind the spectators' barriers, lah, behind the ring, but he was within the ring. So you can imagine the risk, the high risk, okay, because being there. When one of the horses, okay, suddenly, okay, because many horses involved, one of the horses gallop, okay, jump towards him at a significant speed. You can imagine, okay, the speed after the rider lost control of it, and because of that, okay, the horse can knock him down, so he suffered injury lah. Okay, remember he was standing within the ring, okay, not behind the ring, not behind the barriers. So now the photographer, he sued the defendant, okay, in the thoughts of negligence lah. I mean, the rider of the horse was negligent, okay, so he was suing because he suffered injury. All right, so that's what's the issue, because we want to relate to Volenti and free injuria. So the issue now, whether the defense of VNFI should be applicable in this case. Because why? Claimant, I mean, this is the important part, okay? Claimant, the photographer, he was within the ring rather than behind the protective barriers. I mean, we will see whether the fact that he was within the ring, so does it give rise to the defense or not here? So the court held that the defendant, the rider of the horse, was not liable because why? Here, I mean, there's no fault whatsoever, no negligence whatsoever. So the sportsman nearly made an error of judgment. I mean, failed to control the way that the horse galloped whatsoever. Okay, and the claimant, the photographer, had chosen, okay, to position himself close enough, very very close, to risk such error affecting him. I mean, he should have anticipated, okay, the fact that he was being so close to the activity or to the game, okay. So it exposed him to the risk. So as if he consent to the risk. So that's why the difference is irrelevant. I mean, the rider of the horse can make this. Can you right, silent, put in silent mode. Okay. All right, let's go. I mean, we have discussed two cases. The first one not available, but for Woolrich and Sumner here, this is just a classic example in which the court allowed the defense of Volenti and free injury. Because why? The photographer stood so close to the activity or to the game, right? If we twist the facts a little bit, for example, if the photographer sat outside the barrier, okay, not within the enclosure, and still the horse actually jump onto him, then actually the defense won't be available lah. I mean, he can claim for the compensation, but for this particular case, he couldn't claim because he was standing so near, so he took the risk, so as if he consent to whatever risk, and he got injured. All right, so that's the case of Woolrich and Sumner. Okay, let's go to another case. Interesting name. I think it's easy to remember. Condon and Basie. Okay, or in Malaysian Basi lah. Alright, but Condon and Basie. This is a judgment by Court of Appeal against it involve tackle, but now tackle in football. Okay, just now tackle in rugby. I mean, tackle it involve the foot kan, alright, whatever movement I am trying to fight for a ball kan, all right. So here in this case, the claimant, he suffered a broken leg. I mean, it happened during a tackle, okay, especially when it's not properly done. So broken leg during a tackle from defendant. Okay, so it happened in a football match. And the claimant, he was paying for this club, okay, Whittle Wanderers, and the defendant was paying for the Kalsu Football Club. All right, both represent different club. All right, and then both clubs here were in Leamington local league, and this league is actually is amateur, not professional lah. Okay, I mean slightly lower than professional level here. All right, in order to see whether we should apply this defense or not, okay, the court look at the standard of care expected of a football player. And we have different standard, okay, for amateur as well as the professional. Okay, so that's why the court made it very clear. Okay, standard of care varies according to the level of expertise the player has. I mean, similar to the standard of an expert, kan? Alright, for example, normal doctor or a specialist doctor. So now, I mean, similar to this sportsman lah, okay, or to the football player. Okay, level of expertise of the player. And then, as far as the case was concerned, okay, the defendant, I mean, the one who caused injury, okay, in the tackle, was in breach of duty because the tackle was so reckless. I mean, this is something which is beyond norm. Tackle is something which is norm, but then the way it's being done, is it reckless or not? Okay, this is the finding by the court. Okay, the tackle was so reckless, even with regards to the standard expected of a local league player, even though they are not professional, but it shouldn't be done recklessly because it causes injury, okay, to another player. Okay, once a participant can be taken to accept the risk of injury inherent to such sporting activity. I mean, normally everybody knows the risk and they take the risk. But then, if the tackle is done recklessly, they don't consent to it. So they do not accept the risk of injury which occurs outside the rules of the game. So reckless tackle actually it falls beyond the boundary or outside the rules of the game. I mean, it is not part of the game, right? And because of that, substantial damages were awarded for injuries arising from a tackle. I mean, whoever caused the injury during the tackle, so must pay for the compensation. So he cannot plead for Volenti non He cannot say, oh, you consent to the tackle, that's why we are playing together. No, okay? Only normal tackle. I mean, tackle which is within the rules of the game, not reckless tackle, as if something which is above the norm, okay, goes beyond the ordinary tackle here. So again, this is example of in which VNFI was not applicable. I mean, this is different from the case of Woolwich and Sumner. All right. So again, this is the summary. Okay. So the court doesn't allow the defense. Okay, and then that's the reason. Okay. I mean, in quotation, it was made in reckless and dangerous manner. Okay, reckless plus dangerous, and then even though no malicious intention. Okay, but the way it was being done. Okay, the court has this word excitable manner. I mean, so excited. Not excited, happy here. So excited. I mean, it was done without thinking of others situation. Okay, so without thought of the consequences, they just do the tackle without thinking about whatever consequences later. So I mean, it caused injury to the other player, so the court doesn't allow, and that's why the court doesn't allow VNFI. Okay, not applicable for this particular case. Normal tackle, yes, but not this reckless and dangerous tackle or dangerous manner in which the tackle was being done. Okay, so we are done with sports cases. So how many cases that we have? We have Condon and Basie. Okay, we have the case of Woolwich and Sumner. We have the case of Afutu Narti. Okay, so we have at least 3 cases. Okay, but you have more in the textbook actually. So this is all the important cases, but we have all the supporting cases. Let's go to another situation in which VNFI might be argued, okay, by the defendant, by the one who caused injury to the plaintiff. Okay, for rescue cases, okay, for public policy reason, I mean to protect public interest as a whole, usually the court doesn't allow. Okay, the court doesn't prefer that I mean, usually it is not applicable. Okay, because otherwise people won't be taking part in to do the rescue cases. Because if they got injured during the rescue process, they cannot claim. Because why? Or I mean, you be the rescuer, so you consent to the risk. No, okay, the court doesn't accept those arguments. So we have this quotation, okay, or the judgment, not really judgment, quotation or opinion, okay, by Professor Goodhart. Okay, he was quite famous academic jurist and lawyer. I think he's from, I'm not sure from UK or from US, but he was commenting on American rule, okay, in relation to public policy reason. So he said that the American rule, okay, usually American rule and common law rule, they are quite similar, okay, except for certain parts, okay. So here he was saying the American rule is that the doctrine of the assumption of risk, okay, it does not apply, I mean, not relevant where the plaintiff has under an exigency, okay, I mean urgent, okay, urgent situation caused by the defendant's wrongful misconduct, I mean negligence of the defendant, okay? So consciously and deliberately face a risk in order to rescue. I mean, they know, for example, to rescue drowning people, for example, you know the risk, okay? You jump into the lake, so you, I mean, should we allow the claim or not? Usually we should, okay? I mean, we shouldn't allow VNFI. So we have these two cases to illustrate it further or make it clearer, okay? Clearer explanation. Two cases, similar facts, not really similar, but quite similar, but different judgment altogether. Okay, the first case is Haynes and Harwood, 1935, but we are going to compare with Cutler and United Dairies, that one earlier, 1933. Let's have a look. Oh, sorry, before we go to Haynes and Cutler, we go to case Chadwick, in which it explained about public policy reason in rescue cases. The case name is Chadwick and British Railway Board, reported in 1967. It involved a very horrific, tragic train crash. Okay, and it happened in Lewisham, part of, I mean, one place in UK. Okay, and in this incident, okay, in this horrific train crash here, 90 people were killed. So it involved death. Okay, many people died, and many more, I mean, more than 100, obviously, were seriously injured. All right, and then who was Mr. Chadwick in this particular case? Okay, he was the claimant. So Mr. Chadwick, he lived 200 yards away. I mean, quite a distance. I mean, quite nearby, okay, from the scene of the crash. And he attended the scene to provide some assistance. I mean, it's normal. It happened nearby your area. Of course, you will be in the scene and then you try to help, okay, give whatever assistance that you can. And then he was so committed. He really wanted to help, okay. He worked many hours, okay, through the night, and he need to crawl, okay, beneath the wreckage. If you Google, you can see that that's the picture, okay. I mean, very horrific. So beneath the wreckage, and then he need to, I mean, he bring aid, bring help, okay, bring whatever required, okay, and comfort to the trapped victims. So many victims were trapped. So he was trying to comfort them whatsoever. And then, due to witnessing all this thing, okay, as a result of what he had witnessed, he suffered acute anxiety neurosis. You can relate with our earlier topic, never shock. All right, so this is example. Acute anxiety neurosis. All right, and then later he claimed for the compensation, okay, because he was the rescuer. So he was claiming against the train company, okay, British Railway Board here. So the court held that the defendant, the British Railway Board, owed Mr. Chadwick a duty of care because it was reasonably foreseeable that somebody might try to rescue the passengers, and that rescuer might suffer injury, okay, in the process, and it really happened to him as one of the rescuer. Okay, so I mean, we shouldn't allow British Airways to raise the defense of voluntary non-free injury. I mean, oh, you know, this is very terrific, very horrific, and then you shouldn't rescue lah, in a way, kan, if we allow such argument. So the court doesn't allow voluntary non-free injury for policy reason, to protect public interest, to allow, I mean, to encourage people to help. Meaning that here, if they suffer injury later, they can still claim. Voluntary non-free injury will be available, okay, against the defendant who caused the negligence, or who was responsible for this train crash. Okay, let's go to another case. I mean, two cases for us to compare. The first one, Haynes and Harwood, okay, 1936 here. So who was a plaintiff? So plaintiff, he was a police constable, a police officer, okay, and he was on duty inside a police station. I mean, he was working lah, on duty. And then this police station is like a small station, okay. It was located in a busy street. And then it was often attended by many people, including children. I mean, many people, public, right? They're crowded area, busy street. And then who was defendant? Defendant, he owned a two-horse van, because those days there's no car, so we have all the carriage or van. Okay, I mean, two-horse van which is pulled by or cart lah. Okay, here two-horse, and it was left unattended, okay, by its driver in the same street, in the busy street. So you can imagine, okay, the horse together with the van, which is supposed to be carried by the horse, and then the driver, he had actually put a chain on one of the wheels of the van, but then later the chain was subsequently broken. So you can imagine, okay, it might cause injury later, all right, because of the broken chain. And for some reasons, okay, supposedly because a stone, okay, because it was a busy street. So you can imagine what happened. A stone was thrown at the horses. So the horses was so shocked, okay, the horses bolted, all right, I mean, run away lah. Okay, bolted along the busy street alongside with the van. And then the police was inside the station and he saw what happened. Okay, so the police constable, the plaintiff, he saw them, okay, from the police station. So he got out. Okay, he tried to control, he tried to do whatever necessary. So he managed to stop them. Okay, managed to stop the van to get together with the horse, but of course he sustained injuries. Now the police is asking for compensation, okay, claim for damages. All right. So one of the issue which was being raised by the defendant here, okay, the owner of the horse, okay, or the cart here, does the maxim volenti non injuria prevent, okay, on duty police officers from claiming damages for an injury sustained as a consequence of acting whilst being aware of the risk that this involved. I mean, he was trying to control, he was trying to rescue the things, okay, to avoid injury to people, okay, to the public, and then in the process, he suffered injury. So can we, I mean, okay, we have 10 minutes and then if the session end and then we are going to continue, okay, like, I mean, like previous night, right? Sekejap. Because Zoom prompt the message lah to upgrade, I mean to pay to the premium package. Okay, so what's the decision in this case? Okay, so the court held that, okay, the defendants, the owner of the van or the horse here, must or ought to have contemplated, I mean he should have anticipated, can foresee, right, that someone might attempt to stop the horses in order to prevent injury, something which is foreseeable. Okay, and then this maxim, I mean the defense, does not prevent the police constable from claiming damages for an injury sustained. Because why? When he did try to rescue, okay, whatever necessary here, he did not voluntarily agree to take the risk, but he did it pursuant to his official duty. So it's not really full consent to the risk. All right, he did so, but he didn't consent to be injured. All right, and he was injured in the process. So we should allow him to claim. All right. So he was doing the rescue work, but in the I mean within the scope of official duty. So it doesn't stop him from claiming. So we shouldn't allow the defendant to plead for defense voluntary non-fair injury. All right. Let's compare with another one. Okay, Cutler and United Dairies, 1933. Here, the claimant also was injured, similar to the policeman just now. Okay, he was injured when he entered a field to count some horses. So he saw some horses was bolted lah. All right, was I mean try to pacify the horse whatsoever. Okay, and he suffered injury. And then he was asking for compensation because he suffered injury trying to pacify the horse, okay, trying to rescue the situation. Because, but the court said, no, you cannot claim. What's the reason? The horses, okay, presented no immediate danger to persons or property. After all, the court looked at the situation. Okay, where was the horse when it bolted here? I mean, the horse was actually within a field, and nobody was actually within immediate danger. Okay, I mean, totally different compared to the Haynes and compared to Haynes and Harwood, because that what happened in a busy street. Okay, public might got injured. Here, he voluntarily went into the field to calm the horses. Okay. So basically the court said, well, you take the risk and we should allow VNFI to the defendant here. All right. So VNFI is applicable. Lah. Okay. There was no need for him to intervene. Okay. Just to pacify the horse, to calm the horse. And he did it with his full consent. Okay. With full voluntary. I mean, he has the option, okay, to rescue or to calm the horse or not to calm, and he chose to calm the horse. So he agreed or he consent to the risk of injury, and he got injured actually. All right. So that's the difference between Haynes and Harwood, as well as Cutler and United Dairies. One, the first one, not applicable, but for this case, the defense was applicable. I mean, cannot claim for compensation. All right. I think we stop now, and then we are going to continue for another, I mean we are going to continue with this defense, okay, after this. So I stop share for a while. All right. And then I have to stop record as well. Yes.